Hello, listeners. My name is Maya Harris from Troutman, Pepper, Hamilton, Sanders, and welcome to our post-grant podcast. This is episode 3, and I'm joined today by Andy Zappia and Christina Shifton, both of which are in our Health Sciences IP group out of our Rochester office. Welcome, Andy and Christina. So today's topic follows on a few things that we raised in our very first episode talking about IPRs. This time we're going to drill down into real parties in interest. What are they? How are they defined? Why are real parties in interest important? And why might that substantively impact the IPR procedure generally? Christina, let me start with you. What's the source of real parties in interest from a legal perspective?
Sure. So the real parties in interest really comes up in the IPRs right from the beginning because they're part of the mandatory disclosures that a petitioner has to make when they start an IPR. Those come up under both 35 USC section 312A2, and they're also codified in the regulations at 37 CFR section 42.8. So those are things that the petitioner would have to disclose so that the board can check for conflicts, and it also comes up under a couple other sections, which we'll discuss later on how they apply as we go through the IPR.
Right. So this isn't just a conflict check for the board, for the panel, then. This is a substantive issue as I understand it. But given, the importance, what's interesting to me is that it's not actually a defined term in regulatory definitions or statutes. Am I correct with that, Andy?
Yeah, so neither the CFR nor the U.S. Code defines what the real party and interest standard is. So to understand that, you have to look to some other sources. So the board issues a trial practice guide that explains a bit about what real party and interest is supposed to mean. And then the Federal Circuit has addressed the issue in a number of decisions. So in general, the real party and interest it's not a one size definition that fits all scenarios. It's the Federal Circuit has said in the AIT decision, it's really a flexible approach where you look at a lot of factors. And what you want to see is whether a non-party to the proceeding is a clear beneficiary of the proceeding, whether that non-party has an established relationship with the party to the proceeding. And the Federal Circuit says the definition is intended to be expansive. And the trial practice guide says a real party in interest is a non-party to the proceeding that desires review of the patent. You look at it up until the time of institution of a petition, and for a while the case law really focused a lot on the issue of control or opportunity control. So is this non-party to the proceeding in control of a party or have an opportunity to control party? But really, as the case law is developed, that control element is not really required to be a real party in interest.
So it's broader, is what you're saying.
Yeah, it's broader. So even a party that doesn't have control could still be a real party in interest. And the Federal Circuit in the Wi-Fi 1 case said that really you're looking for non-parties to the proceeding, sort of at whose behest the proceeding is being instituted or pursued, right? So it goes to this whole beneficiary concept. So it's a fairly broad concept, right? It's very fact dependent. So for example, usually for a petitioner, you want to disclose parent companies of the petitioner, because the idea there is a parent company of like a wholly owned sub, and the petitioner in an IPR proceeding is a wholly owned sub. Usually it's a good practice to disclose the parent as a real party in interest, but it doesn't necessarily go the other way around, because there's not a requirement to disclose subsidiaries of a petitioner unless some other factor is in play.
So interesting. So it's on the one hand broader, but on the one hand narrower than a concept of control, then, is what you're saying.
Right. Well, and the issue is if you're controlled by the petitioner, you may or may not be a real party in interest. So it's messy, right? So a lot of times petitioners will opt to be pretty expansive in their disclosure of real party in interest, so they don't get tripped up and not having disclosed some person or entity that they should have disclosed. And I should mention that a patent owner also has to make these disclosures. So after a petition is filed, a patent owner has to put in mandatory disclosures, and the patent owner likewise has to disclose its real party and interests as well. So they both petitioners and patent owners have to make this real party and interest disclosure.
So, Christina, why does this matter? Sounds to me like this is just a big list of names.
Well, the big issue that comes up in these IPRs is whether the petitioner or the patent owner would be time barred from filing an IPR. So this will come up under 35 USC 315 A and B. The time bars, briefly, you can't file an IPR if before the IPR was filed, the petitioner or an RPI or privy filed a complaint challenging the validity of a patent. You also can't file an IPR more than 1 year after the petitioner or the RPI or privy was served with a complaint alleging infringement of a patent. So those time bars can be a big issue on whether the petition for an IPR is timely and therefore whether it can be instituted.
So hold up, we were just talking about control and we were talking about parents. What's this privity thing?
Privity. This is Andy. So, as Christina mentioned, there's these time bars, right? And for the disclosure requirement applies to real parties and interest, but Congress, in writing one of the time bars, which is the time bar for 315B, which is you can't file an IPR after more than a year after you've been sued for infringement. You can't file an IPR. Congress threw in this term privy. So it says petitioner or a real party in interest or privy of a petitioner. So this creates this issue of privity, right? So it's something different from real party in interest. It's a similar concept, but likewise, it is not defined. It's not defined in regulation or statute. So again, you got to look to the trial practice guide issued by the board, and you have to look to primarily Federal Circuit decisions to figure out what is this concept of privity. And what the Federal Circuit has said, and one of the decisions is this decision, Power Integrations, is you really look to the common law concepts of privity, and the focus is on the legal relationship between the parties. So they really go back to common law principles to look at privity, and they go back to a Supreme Court decision, this Taylor decision, that looks at 6 factors relating to preclusion. Factors include like agreements between this third party, pre-existing substantive legal relationships, whether a party adequately represents the third party. You look at control. Is the party acting as a proxy for a non-party to the proceeding? You look at special statutory schemes that might expand the concept of this privity theory. So it's really, it's going back to the common law on preclusion. And basically the theory is, if under common law, this non-party to the proceeding could be subject to preclusion, that non-party could be considered in privity with the party. And the trial practice guide says the same thing. It says you look to whether the non-party to the proceeding should be bound by the outcome of the IPR. So in concept, because privity is broader, if you're found in privity, you're necessarily going to be found as a real party in interest as well.
Does that mean, just as for clarification though, does that mean that the petitioner not only has to disclose real parties in interest as those are defined in various places, but also has to start identifying what parties might be in privity? So
the regulations and the statutes only require disclosure of real parties in interest.
Okay, it's just that the time bar sections would apply both to real parties in interests or privities.
Now, from a practitioner standpoint, if you have a party that is would meet the privity standards, if you're a petitioner and you're aware of a non-party to the proceeding, so an entity that would not be a petitioner, and you think that that party meets the privity standards, I think it would be wise to disclose that party as part of the mandatory disclosures, and that way you wouldn't be accused of failing to disclose and hiding the ball in some way. Technically, the disclosure obligation applies to real parties in interest. So, but where this really comes up is where this privity, this non-party to the proceeding, is potentially in privity, and there's some sort of time bar issue with regard that non-party to the proceeding, and that's where the major issue comes up. So if there's not a time bar question, my personal view is you're better off just disclosing these potential parties in privity, because that way you can't be accused of not having disclosed something and that the board might want to know. And so.
And it sounds like this is, again, is a relatively fact-intensive review. Do you have to meet all 6 of these factors that you just laid out?
Well, the board held in this Ventex decision that if you meet any one of them, that can be enough for privity. So it's a 6-factor test, but at least the board's view, and that decision is a precedential decision by the board. One can be enough of these multiple factors. So
interesting. Interesting. So let's talk a little bit more about these time bars then. How are time bars applied with respect to real parties and interests? Let's start there, Christina.
Sure. So the time bars in the real party and interest context are very fact intensive. Like we've been talking about, the board is really going to grapple with the entirety of the relationship between the parties. The Federal Circuit has told us in the AIT decision, which was then remanded back to the board, that you have to take into account the whole relationship and look at all the equitable and practical considerations between the parties. So they'll look at who's going to benefit from the IPR itself. They're going to look at whether there was a pre-existing established relationship, whether there may have been control. They're going to take all of those factors and look at them and try and get a look at the entire relationship between the parties. And there's been a few decisions that have fleshed out a little bit of how they look at this. The Ventex decision and the AIT decision have both been named as precedential decisions by the PTAB. So those are decisions that go through the factors and discuss the relationship that existed there. Starting with AIT, because it's one of the most recent precedential decisions. There was a party, RPX, who was the petitioner, who provided patent aggregation services to their clients. One of the clients, Salesforce, was alleged to be an RPI, a real party in interest to RPX. Initially, the board found that they were not a real party in interest, went up to the Federal Circuit. The Federal Circuit determined that they had used too narrow of a definition of real party in interest and remanded back to the board to take a look at it again. And on remand, the board this time said that Salesforce was a real party in interest of RPX. In doing that, they looked at how RPX was structured, what their business practices were. They looked at how Salesforce had interacted with them, what communications there had been between RPX and Salesforce, and generally whether Salesforce was going to be the one to benefit from the challenge to the patents that had been brought by RPX. So at the end of the day, RPX and Salesforce were real. Salesforce was the real party in interest to the IPR, and therefore, because Salesforce was time barred, the IPR was denied. That's a similar situation to what happened in Ventex, although in Ventex it was a customer-supplier relationship. The alleged unnamed real party in interest, Sirius, was a customer of the petitioner Ventex. Ventex had expressed that it wanted to protect its customers, and Ventex filed an IPR against the patents to protect its customers from challenges, from infringement lawsuits. Sirius had been sued by Columbia for alleged infringement of a patent, and Ventex then filed this IPR after it had also intervened in the underlying lawsuit. In the board's decision, they did a very fact-intensive look at the entire relationship between Ventex and Sirius, what agreements existed, the terms of those agreements, whether there was indemnification obligations.
I was just going to ask that
Yep.
question. Was there an indemnity obligation in that situation?
There was. Ventex had an obligation to indemnify Sirius. But the board also noted that even in the absence of an indemnification obligation, that they may have still found a real party and interest relationship. So indemnification could help with that finding, but it's not necessary.
Interesting. Now, how, if at all, is that different with respect to situations where the question is one of privity?
So on privity, the analysis is similar. They look at a lot of similar factors, although, as I mentioned, the board has indicated that privity is a broader concept than real party and interest, right? And the major focus on privity is whether the relationship is close enough that preclusion would apply. Because as I mentioned, they really looked at common law standards for privity and preclusion as part of that analysis. So the Ventex decision that Christina mentioned also involved a privity analysis, and they went through these factors from this Taylor Supreme Court case. And Ventex, as I mentioned, said that any one of those factors could be enough to find privity. And again, and AIT also talked about privity. AIT mentioned that if you are a real party in interest, you'll also generally be in privity. But they didn't get into the merits of the privity issue because there was an issue about whether it was properly raised to the board, et cetera. So that AIT was decided primarily on real party and interest, but they did note that if you're a real party in interest, you're generally going to be in privity, since privity is a broader concept. Now,
can I just stop there for 1 second? I'm sorry, just out of curiosity, can we come up with a situation? Because I would have said, just before this conversation, if you had asked me, just like stop me on the street and ask me, would a customer, supplier relationship be one in which one or the other was a quote unquote real party in interest versus one of privity? I probably would have said that probably falls into a privity category, but not a real party and interest category. Just like, again, person on the street reaction. Is there can you think of a situation where there's going to be, privity applied in a situation where the board would likely not find a real party and interest? Or are we really kind of seeing a convergence of these two concepts?
I think there's a fair amount of convergence.
Okay.
Because but I can't say the board has spoken definitively to that, and they usually do analyze the two factors separately. But when you look at the Taylor factors for privity, and you look at the issues that the board has focused on for real party and interest, and a lot of it turns on, beneficiary of the proceeding, at whose behest the proceeding was filed. Conceptually, there's a lot of overlap between the two, right? And I think where a lot of decisions come out is if the relationship is close enough, they're going to find it as one or the other, right? And then if they find it as one, they might not analyze it under the other, because they may feel, the board might feel it's not necessary, right? Ventex did analysis on both sides of the issue, but there's an awful lot of overlap in the analysis between the two.
I mean, that's interesting in and of itself. How are you seeing this play out in practice then?
Sure. So I can talk about, one case that our team handled, and there's some of the material subject to protective order, so I won't get into the specifics, but we were hired by a patent owner to file preliminary responses against some petitions filed by Microsoft, and our client was SAIC. This is all public. And initially, this dispute started with a lawsuit against the U.S. government for patent infringement. And more than a year passed after those initial suits were filed against the U.S. government. The U.S. government did a contract with Microsoft. Microsoft ended up intervening in the lawsuit against the U.S. government. This was in the Court of Federal Claims, where you can bring claims against the U.S. government. And then later, Microsoft filed 5 IPRs on these patents. And the issue that came up is the U.S. government a real party in interest or privy of Microsoft? And since more than a year had passed since these suits were filed against the U.S. government, should Microsoft be barred, time barred from bringing these IPRs? And the board said yes. The board found those IPRs time barred under a privity theory. The board analyzed a lot of different facts related to the relationship between the two. I won't talk about those because some of them are under seal and some of those facts are redacted from the decision. But ultimately, the board looked at the relationship between Microsoft and the U.S. government and determined that the two were in privity and denied institution on all 5 of those IPRs. And one element of that, just to talk about a practice point, it's hard to get discovery in IPRs, right? But you can make a request for discovery. And in this particular proceeding where we were involved, after we got the petitions, we went to the board and asked for discovery of documents relating to the relationship between Microsoft and the U.S. government, because we said it was really necessary for us to be able to present arguments in our preliminary response. And we did get discovery ordered. We did get document production of various documents relating to the relationship. And those were used extensively in our preliminary response. And we also put in a surreply on our preliminary response to march through why the facts of the relationship between Microsoft and the U.S. government supported our position. And the board then addressed those facts in its decision and found a privity relationship and a time bar. So as part of the practice here, you will frequently see patent owners, if they think there's an issue on this and they think there might be a time bar, but they don't have all the information, they can go to the board and seek leave for some discovery. And the standard is a little difficult to get, but we've had some success in different contexts of getting the board to authorize discovery. And this is an instance where we were able to get it, because without that discovery, it would have been difficult for us to make our argument.
That was my next question.
Yes.
What were the underlying facts that you learned important for the decision, do you think?
Absolutely critical. I can't say what they were, but I can say that they were critical for us to show a privity relationship.
Okay, so we have spent a lot of time talking about time bars today. Do real parties in interest have any other place in any other analysis related to IPRs? Christina?
Yes. So as we talked about at the beginning, they come up first in those mandatory disclosures that happen at the beginning of an IPR. But they can also come up after the IPR has concluded under the estoppel provision of 35 U.S.C. 315E. Those provisions generally prevent a petitioner from raising issues that were raised or could have been raised in an IPR, from raising them again in a subsequent PTO proceeding or in district court litigation. A failure to name a real party in interest is not generally a basis to deny institution. The PTAB the board has generally said that they will just allow the mandatory notices to be amended unless there is some other factor that has been raised. There's a few precedential decisions from the board that have addressed this, but in general, you have to find either the petitioners attempting to circumvent a time bar or the relevant estoppel rules. You have to find that there's some sort of prejudice to the patent owner, some sort of bad faith on the part of the petitioner, or some gamesmanship that would lead the board to conclude that there was a reason to deny institution of the IPR based on a failure to name a real party in interest.
So it sounds like there's two different issues here. There's the estoppel issue, and then there's you might get in trouble if you fail to disclose a real party in interest the first time around. Is that fair to say?
The estoppel is important because when this estoppel is triggered by a final written decision, it applies to both the petitioner and a real party in interest of the petitioner, right? So that's why it's important in the mandatory disclosures that you properly disclose real parties in interest, because that defines who's subject to estoppel, right? And that's how that issue can arise. Amending or correcting the disclosures, that's usually allowed unless one of these sort of bad faith factors or prejudice factors, one of those is in play. Otherwise, the board will usually let you correct it, basically, unless there's some sort of bad conduct.
How about appealability? Are any of these decisions appealable?
So denials of institution, where this issue comes up most often, those are not appealable. It used to be the case that certain issues could be appealed relating to denial of institution, but the Supreme Court in the I never know how to pronounce this decision.
Yeah, how do you pronounce that
decision? Chrissy, I only know, Chrissy, if you know how
I always say Thrieve, but none of it
whatever
makes
it's called. It's THRYV, but they basically said there's no appeal of denials of institution. And that's pretty much the landscape. The Federal Circuit has not really wanted to get into the institution business, and they've stayed away from it. The estoppel, and whether you're subject to estoppel, so you're a non-party to the proceeding and the dispute has arisen, whether you're subject to estoppel, whether that could arise in another PTAB proceeding, it could arise in district court. If you're found to be subject to estoppel as a non-party to the IPR proceeding, there is case law to say that you can appeal that finding. But as far as a denial of institution based on a time bar, that's not appealable. So, for example, in my Microsoft SAIC case, after we obtained a denial of institution in those 5 IPRs, Microsoft attempted to appeal. This was before this Supreme Court decision. We moved to dismiss the appeals. The Federal Circuit actually dismissed the appeals before the Supreme Court decision, just a couple days before the Supreme Court decision came out, finding that this sort of denial of institution is not appealable. So in general, so I guess the takeaway is appeal rights are really limited in this area if you're dealing with a denial of institution, and then except estoppel. Now, it is theoretically possible that an issue of time bar or real party in interest, one of these things is raised in a preliminary response, but the board might say, well, we're not going to, we don't have enough facts to resolve this now, or X or Y, we'll deal with this in final written decision. And if these factors were, I think that's rare. I'd have to see if the board has really done this, but if it's in a final written decision, it can be appealed, right? So really, this discussion of non-appealability is really about non-institution decisions. So if this percolates later and it ends up in a final written decision, for example, a time bar issue comes up later and it ends up in a board final written decision, I would think that would be appealable because the statute's clear that final written decisions can be appealed to the Federal Circuit.
All right, let's wrap this up because this has been really interesting, but I want to hear just off the cuff what our takeaways are. Any important practice points that we want to leave our listeners with today?
As a petitioner counsel, be very conscious of who could be a real party in interest or a privy, and also check and see whether those entities have ever challenged the validity of the patent previously, or have they been sued on any of the patents that you're planning to challenge in IPRs, right? Because you want to know, if there's a lurking time bar issue, you want to know, right? You want to advise your client about it. You want to prepare for it. If there is one, you may have to have a discussion about whether you can really even pursue this IPR, right? Because if you think there's a valid ground the other side could raise for a time bar. So I think that's really one of the key issues to consider. And then in view of estoppel, I always advise clients in IPR who want to file an IPR as a petitioner, be conscious of estoppel, understand it, because it will apply to you if it goes to final written decision. And it will apply to you, and it will apply to your real parties and interests. So just be aware of that, because that's one of the impacts of deciding to pursue an IPR. You have to accept that possibility.
What about on the other side? Any practice pointers if you're the patent owner?
If you're the patent owner, when you get a petition, you want to see who they've listed as real parties in interest, right? And you want to kick around, do a little research and see, is there somebody not listed that you think should have been? And obviously you want to know what's happened with your patents. Who have you been enforcing them against? What kind of arguments have been raised? Anyone filed a DJ of invalidity against your patents? Who are those parties and what their relationship might be with the petitioner, right? Because if you think there might be a relationship and you can support it, you might want to go to the board and say, hey, I want some discovery here, because I think there's a non-disclosed entity or person that should have been a real party in interest, or we think also could be a privity, and we think there's a time bar, so we want some discovery. And you can even, in theory, get third-party discovery from the board, but it's really rare. Let me just say that. Like a
that's another topic. That's another topic.
Theoretically,
for the board, right?
I've never been successful at it, but theoretically. But so that's as a patent owner, go through who they list, and just think about it. Don't just glance over that part of the mandatory disclosure. Just think about who they list, because you may have an argument to stop the proceeding right up front.
Music to every client's ears.
If you're a patent owner, yep.
All right, I revised that. Music to every patent owner client's ears.
Right, exactly.
Very good. Very good. All right. Well, thank you, Andy. Thank you, Christina. Thank you to our listeners. This has been an excellent discussion. I hope you enjoyed it too. We invite you to join us for our next installment of this podcast series discussing strategy, trends, and other happenings at the PTAB. Our next episode is going to be covering one of my favorite topics, reissue. Troutman Pepper's intellectual property team helps clients develop and implement global protection and commercialization strategies for intellectual property assets in virtually all industry areas. For more info about how we can help you, visit the intellectual property section of Troutman.com. You can also subscribe and listen to other Troutman Pepper podcasts wherever you listen to podcasts, including Apple, Google, and Spotify. Thanks again to our listeners. Thank you, Christina. Thank you, Andrew.
Thanks, Maya.
The views and opinions expressed in this podcast are solely those of the individual participants and not Troutman Pepper or its clients. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at Troutman.com.